So it's no secret that over the past year, several businesses had to lay off and furlough employees due to the pandemic. However, now that it's time to hire and rehire employees, there are several things you need to consider, one of which is employment agreements. I'm Skye Schooley, a staff writer with business.com, and today I'm joined by Kevin Murch, an attorney with Perez Morris, to discuss what kind of legal considerations you should keep in mind when creating employment agreements for rehiring those furloughed and layoff employees. Just to start off, can you just give our viewers a little bit of background on what an employment agreement is and why it might be beneficial to have one?
Sure. So basically, it's the agreement between the employer and an employee. And it sets forth really just the basic terms and conditions of the employment relationship. They can be really as detailed as you want them to be. They can be fairly vague and just hit some key points. The reason that they're useful is, and also sometimes why it may not be a benefit, is it really locks everybody in. So everybody understands what the deal is, what you can do, what you can't do, what salary, benefits, work responsibilities, the term of employment. So especially if it's a situation where you want to hire somebody for an X period of time. Otherwise, you want to make clear in there that it's an employment at will, which basically means that either side can terminate whenever they want to. And sometimes with respect to the termination of the relationship, you want to have some provisions in there as far as what is the process for terminating. So, how much time does the employee have to give before he or she terminates the relationship? And then also, what does the employer have to do and how much notice has to be given? And then sometimes they'll also work out if there's going to be any sort of compensation upon termination and things like that. One thing that I do a lot in my practice is enforcement of restrictive covenants, like the non-compete, the non-solicitation. So you want to have those in there for the appropriate employees. It's not always necessary, but that's really the way that you would restrict somebody's post-employment activity, so they don't start going after your employees, going after your customers and clients and things like that. And also you can have things in there such as whether you want to have some sort of a dispute resolution provision like arbitration, venue provisions as far as if we need to litigate some matter, where that's going to happen and what law will apply. So these are all things that you would put in that agreement. Again, why it can be useful, because everybody knows what's going on with the relationship from day one.
If an employer wants to rehire an employee that they had laid off previously, are there any legal risks that come with that? And if so, is there something that you can do with the employment agreement, a way to tailor it to best suit that situation?
Sure. Yeah. And I don't know if I would necessarily call it a legal risk. I guess there are certain things that you want to look out for. And I know we're going to talk about furloughed employees as well, and kind of the difference there with a laid off employee. Is it's somebody who they were laid off, obviously, with really no anticipation that they are going to come back. But as economic factors get better, it may look like, hey, we need to bring some more people back on. These were some good folks who worked for us before. Let's reach out to them. I guess the one, again, like I said, I don't like to say it's a legal risk, but one thing to keep in mind is if you did have an employment agreement with that laid off employee, that's no longer going to be in effect. Because once that relationship terminated the first time through the layoff, you can't rely on that any longer. And so there are certain things you're going to have to do. Primarily, you're going to have to restart the employment relationship over. So it's basically a new hire. It's like somebody that you've just hired for the first time. So you're going to have to do things such as the employment verification process with the I-9. You're going to want to make sure that you do that because that's mandatory. Again, we talked a little bit ago about restrictive covenants and things like that. If those were in the previous employment agreement, you're going to have to get a new agreement put in place in order to be able to restrain that employee should he or she leave and try and go compete or whatever it may be. You can't rely on that old agreement. So that would be the main thing that I would point out. Also, along with that, it's probably a good time to update your employee manuals, your handbooks, especially if it's something like what we're coming out of now with COVID, where an employer might be bringing on several new hires and several people that they laid off previously, it's a good time to look through those manuals and the policies, any other handbooks that you might have to figure out, okay, do we need to make changes now? What is the scope of our business? What does the landscape look like now? What changes do we need to make? And you need to make sure that you get the rehired, I guess, employees to sign off on acknowledgement forms, on anything indicating that they've read, that they agree to comply with everything in the handbook. Again, things that you would do with any new hire, you have to do with somebody even though they worked for you before, because once they were laid off, that previous arrangement, employment relationship, for lack of a better phrase, terminated. So it's over. And so you're starting new with something else. And so along those lines, if you do have people enter into employment agreements, you have to do a new one with them. And then you need to tailor it to what their job looks like now. Because again, and we'll talk about this a little bit with the furloughed employees, what they come back to may not be what they left. Companies may have found during this year or so that we don't need somebody doing A, B, and C, that there's redundancy, whatever it may be. So it's a good time to also probably put out a new offer letter or an agreement with what their new responsibilities and duties are going to look like. Because again, it's not going to be the same as what it was.
Great. And you had already kind of foreshadowed it, but in terms of rehiring those furloughed employees, how does that, what are the legal considerations and how does that come into play with your employment agreements?
Yeah, the one thing, and I guess here I might use the legal risk phrase that you used previously. I think the first thing to consider is, especially if there's been a group of employees that were furloughed, is who are you bringing back and why? And the reason that's important is because you're going to, presumably, if it's a larger group of employees who are furloughed, they're going to, run the spectrum from race, ethnicity, age, gender, everything else. And you want to make sure you're not inviting a lawsuit. You certainly don't want somebody to feel like, boy, I wasn't called back as quickly as this other person that I've worked with for years, and I feel like I have more experience. And you want to make sure just that you have, a legitimate business interest and reason for bringing the people back that you've brought back, and in what order you do that. I think some states have some laws with respect to bringing back furloughed employees, sometimes requiring you go by seniority and things like that. So it's very important to look into those matters, as well as your own handbooks and policies that you might have in place. Some employers may have very old handbooks and policies in place that they haven't reviewed in a long time. And they might cover situations as far as when employees are furloughed and when they might need to come back. And not to go, too far into the weeds, but there's also collective bargaining agreements and unions and things like that. So I think that's the initial step, is who are we bringing back and why, and want to make sure we're not leading with our chin and inviting any lawsuits in the way that we're doing it. The other thing that probably helps at that initial phase is to send off a letter to everybody. I've seen them called recall letters, or sort of invitation to come back to work letters, with a date certain as far as this is when we want you to come back. Because some folks, as we've seen during the lockdown and what's been going on, some people have simply moved away. I mean, I have a client who he was furloughed and he decided, I'm going to go live somewhere else and maybe I'll work remotely or maybe I'll find something else. So they may find that people have found new jobs, or they've decided I'm going to do something different with my life. So thank you. But no, thank you. And then that way you can then go down your list of furloughed employees to bring back. And then also, with everybody being gone in some instances over a year, there might be some concerns as far as what have these folks been into over the past year. So there might be a thought of, should we do a background check again? And, meaning getting into the criminal background and things like that. Some employers might have clients who would require that and say, before anybody can work for us, they need to go through this. So it kind of puts the onus on the employer to make sure that happens. So make sure, if you are going to do these background checks again, that you have the proper authorizations to do it. Once again, I would not rely on authorizations that the folks signed when you first hired them, even though furloughed employees, like we said, are a little different in that they were placed on leave. unpaid leave for the most part, obviously. And they may, they may have signed something before where they said, yeah, you can do a background check, but it was maybe a one-time background check. And it's important to look at those authorizations. Some authorizations are general and will allow for a background check at any time during the employment relationship. So the employer could take this as, the employment relationship still continued, but the person was just furloughed. So we can rely on that authorization. But it's probably best, belt and suspenders, so to speak, to just get new authorizations to do the background checks, and other things to keep in mind, much like with a new hire, is if there is some adverse information on that background check, most states will require that the employer give some sort of a notice to the employee and say, hey, we found this, and give them an opportunity to present any mitigating facts or some explanation instead of just saying, you know what, we're not going to recall you now. We saw this thing on your record. It kind of gave us a bit of heartburn. So we're not going to follow through with your recall and you're still furloughed, or we're just going to go ahead and terminate you outright. So and then shifting to the agreements, again, the landscape may look completely different now. And what the folks are coming into might be completely different, with job responsibilities maybe being added or taken away. There might have to be some changes to salary. So again, I wouldn't necessarily rely on whatever the previous employment agreement was, because things may have changed enough on the employer side that you don't want the employer to be able to then say, well, we have this agreement and you've breached it. I would hope that prior to the furlough process, especially if the furlough process was not covered in a previous agreement or it wasn't part of your handbook or policy, that there were some discussions when this was happening as far as, we have to do this. The alternative is termination. So we don't want to do that. Let's do it as a furlough and let's reach some agreement. Hopefully that's happened. But if it hasn't happened, I think it's important to try and get a new agreement or amend the previous agreement, make sure it's in writing, obviously. So again, it fulfills that same purpose of the employment agreement. Everybody's on the same page. Everybody knows what their duties are, responsibilities in any given circumstance. So again, I think it's all just, we need to reflect on where we are now. What does our business look like now? And how do we address this through the agreement to make sure this person's job is still accurately reflected in their agreement? And so I think that's critical.
And lastly, when employers are rehiring employees, are there any other things that they should consider legally?
Yeah, I mean, one thing I was thinking about, and it's kind of goes a little bit hand in hand with a background check, but again, some people may think, I don't know what this person's been doing the past year. And when they hire somebody new, they may, again, depending on the business, they may require a drug test. So it may be something that employers are looking into now, that, this person hasn't worked for me for over a year. I haven't heard from this person in over a year. So why don't we treat them like a new employee and maybe do a drug test? The problem with that is in some states, they don't really allow drug testing if you don't really have a basis to believe there's a reason that the person is maybe under the influence. So if you don't really have any suspicion of drug use, some local laws may prohibit it. So you're going to want to look into that as well. And then, there are absolutely certain employment situations where, that's probably something that you should be doing anyways, somebody with a commercial driver's license, things like that, where that's probably fairly commonplace. And then the other thing along those lines, and we talked about it a moment ago, is with respect to the employment verification in the I-9. Like I said, if it's somebody who was laid off, you're going to want to treat them like a new employee, and you're going to do that with a new employee anyway. So there's a bit of a rule of thumb with respect to somebody who's been furloughed, and if they've been if they've been gone for a long time, you may want to run that process again, just to make sure your paperwork is complete. I think I think it's if you've got their original I-9 and it's less than 3 years old, you're probably fine. But if it's more than 3 years and they've been gone for a long period of time, almost to the point where it almost looks like it was a termination, then it's probably best to just go ahead and do that employment verification again, just to make sure that everything you have in your records is complete, everything is up to date, and so you don't run into any issues down the road. So a lot of it really is kind of common sense, but a lot of it also is what I would tell employers when you're bringing folks back is look and see what is already in your policy or the previous employment agreement, handbook, whatever it may be. There may be situations such as the handling of vacation time, personal time off, other benefits like that, where you might have an old policy that says, and let's just think about the laid off folks, you may have a policy that says that if you terminate somebody or they leave, but then they come back within X number of months, they may still be entitled to benefits and accruing leave and things like that at the rate they were at when their employment terminated. And so you don't want to get stuck in a situation where you really are treating everybody just like a brand new employee who's never set foot in your facility before, when in reality you already have an agreement or something else in place that shows that they would be entitled to that. So again, I think that's just kind of more common sense. Look at what your records say, what your policies are, and make sure that in bringing folks back, you're not violating any of those. And then assuming you're not, and you might want to update those, as we said, and then also get agreements in place that are tailored to the current situation.
Great. Well, that was all that we had for today, Kevin. Thank you so much for your time.
Sure. I appreciate it. Thank you.